Ms. Larson, if you'd please have the jury join us. Please rise for the jury.
Please rise for the jury.
Please be seated, everyone. Good morning, jury members. We're very, very happy to have all of you here in your places. Hope you enjoyed the nice weekend, and were able to get some rest. We are about to begin. We're in the final stretch, folks, and I had some computer problems this morning. I apologize for making you wait. I had made some edits over the weekend, and then my computer took about 3 starts before it was going to come play this morning. So, but we're all good. As I said, there will be instructions that I will give you. Throughout this process, you have served as the judges of the facts. And when you begin your deliberations, you will be determining the facts that you find to be credible and base your decision based on those facts. The instructions that I will read you this morning is the law that applies in this case. And so don't feel that you have to write down anything that seems important. You will have written copies of the instructions that I will read. We will provide enough copies of those instructions that you will be able to look onto a copy so that everyone will be able to look at those instructions. Don't feel like you have to take notes on what I'm going to tell you this morning. I'm going to read a portion of those instructions to you, and then the attorneys will have an opportunity to give closing arguments. And then there will be a few more instructions that I give you, and then we will allow you to retire to the jury room to begin your deliberation process. I just have a couple of, I won't make those remarks at this point. We will go ahead and get started with the reading of the jury instructions. State of Iowa Plaintiff versus Jerry Lynn Burns, Linn County cause number FECR 129718, statement of the issues and instructions of the court. Ladies and gentlemen of the jury, the state of Iowa in this case accuses the defendant, Jerry Lynn Burns, of the crime of murder in the first degree when he willfully, deliberately, and with premeditation killed Michelle Martinko. This occurred on or about December 19, 1979, at 2400 Edgewood Road Southwest, Cedar Rapids, Linn County, Iowa, in violation of Iowa Code Sections 707.1 and 707.2, subsection 1. To this charge and all lesser included offenses, the defendant entered a plea of not guilty. Upon the issues thus made, you are instructed as follows. Instruction number 1. The trial information charges the defendant, Jerry Lynn Burns, with the crime of murder in the first degree. Murder in the first degree includes the lesser and included offenses of murder in the second degree, voluntary manslaughter, involuntary manslaughter public offense, and involuntary manslaughter reckless conduct. Instruction number 2. The trial information is the document that formally charges the defendant with a crime. It is merely the method by which the defendant is brought into court for trial. It is not evidence. Instruction number 3. Jerry Burns has entered a plea of not guilty. The plea of not guilty is a complete denial of the charge and places the burden on the state to prove guilt beyond a reasonable doubt. Whenever I instruct you that the state must prove something, it must be by evidence beyond a reasonable doubt. If the state does not prove the defendant guilty beyond a reasonable doubt, your verdict must be not guilty. Instruction number 4. Jerry Burns is presumed innocent and not guilty. This presumption of innocence requires you to put aside all suspicion which might arise from the arrest, the charge, or the present situation of the defendant. The presumption of innocence remains with the defendant throughout the trial unless the evidence establishes guilt beyond a reasonable doubt. Instruction number 5. Jerry Burns is presumed innocent and not guilty. The presumption of innocence requires you to put aside all suspicion which might arise from the arrest, charge, or the present situation of the defendant. The presumption of innocence can be overcome only if the prosecution proved during the trial, beyond a reasonable doubt, each element of the crimes charged. Instruction number 6. You must determine whether the defendant is guilty or not guilty from the evidence and the law in these instructions. My duty is to tell you what the law is. Your duty is to accept and apply this law and to decide all fact questions. You must determine the defendant's guilt or innocence from the evidence and the law in these instructions. You must consider all the instructions together. No one instruction includes all the applicable law. Instruction number 7. The duty of the jury is to determine if the defendant is guilty or not guilty. In the event of a guilty verdict, you have nothing to do with punishment. Instruction number 8. Nothing I have said or done during the trial was intended to give any opinion as to the facts, proof, or what your verdict should be. Instruction number 9. The burden is on the state to prove Jerry Burns guilty beyond a reasonable doubt. A reasonable doubt is one that fairly and naturally arises from the evidence in the case or lack or failure of evidence produced by the state. A reasonable doubt is a doubt based upon reason and common sense, not the mere possibility of innocence. A reasonable doubt is the kind of doubt that would make a reasonable person hesitate to act. Proof beyond a reasonable doubt, therefore, must be proof of such convincing character that a reasonable person would not hesitate to rely and act upon it. However, proof beyond a reasonable doubt does not mean proof of all possible doubt. If, after a full and fair consideration of all the evidence, you are firmly convinced of the defendant's guilt, then you have no reasonable doubt and you should find the defendant guilty. But if, after a full and fair consideration of all of the evidence in the case, or from the lack or failure of evidence produced by the state, you are not firmly convinced of the defendant's guilt, then you have a reasonable doubt and you should find the defendant not guilty. Instruction number 10. If there is a reasonable doubt as to the degree of the crime, the defendant shall only be convicted of the degree for which there is no reasonable doubt. Instruction number 11. You shall base your verdict only upon the evidence and these instructions. Evidence is, number 1, testimony in person or by telephone. Testimony in person or by deposition. Number 2, exhibits received by the court. You may examine the exhibits closely, but be careful not to alter or destroy them. Number 3, stipulations which are agreements between the attorneys. Facts may be proved by direct evidence, circumstantial evidence, or a combination of both. Sometimes during a trial, references are made to pretrial statements and reports, witnesses' depositions, or other miscellaneous items. Only those things formally offered and received by the court are available to you during your deliberations. Documents or items read from or referred to which were not offered and received into evidence are not available to you. The following are not evidence: statements, arguments, questions, and comments by the lawyers. Number 2, objections and rulings on objections. Number 3, any testimony I told you to disregard. Number 4, anything you saw or heard about this case outside the courtroom. Instruction number 12. Decide the facts from the evidence. Consider the evidence using your observations, common sense, and experience. Try to reconcile any conflicts in the evidence, but if you cannot, you will accept the evidence you find more believable. In determining the facts, you may have to decide what testimony you believe. You may believe all, part, or none of any witness's testimony. There are many factors which you may consider in deciding what testimony to believe. For example, number 1, whether the testimony is reasonable and consistent with other evidence you believe. Number 2, whether a witness has made inconsistent statements. Number 3, the witness's appearance, conduct, age, intelligence, memory, and knowledge of the facts, and the witness's interest in the trial, their motive, candor, bias, and prejudice. Instruction number 13. In considering the evidence, make deductions and reach conclusions according to reason and common sense. Facts may be proved by direct evidence, circumstantial evidence, or both. Direct evidence is evidence from a witness who claims actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is evidence about a chain of facts which show a defendant is guilty or not guilty. The law makes no distinction between direct evidence and circumstantial evidence. Give all the evidence the weight and value you think it is entitled to receive. Number 14. Where there are two or more alternative theories, let me begin again. Instruction number 14. Where two or more alternative theories are presented, or where two or more facts would produce the same result, the law does not require each juror to agree as to which theory or fact leads to his or her verdict. It is the verdict itself which must be unanimous, not the theory or facts upon which it is based. Number 15. You have heard testimony from persons described as experts. Persons who have become experts in a field because of their education and experience may give their opinion on matters in that field and the reasons for their opinion. Consider expert testimony just like any other testimony. You may accept it or reject it. You may give it as much weight as you think it deserves, considering the witness's education and experience, the reasons given for the opinion, and all the other evidence in the case. Number 16. The witness, Michael Allison, has admitted he was convicted of a crime. You may use that evidence only to help you decide whether to believe the witness and how much weight to give his testimony. Number 17. You have heard in this case, this is instruction that has been numbered as 18, but it will be number 17. In this case, the defendant has decided not to testify. The defendant is not required to testify, and no inference of guilt shall be drawn from that fact. The burden of proof remains upon the state to prove the guilt of the defendant. Evidence has been offered to show that the defendant made statements at an earlier time and place. If you find any of the statements were made, you may then consider them as part of the evidence. Instruction number 20 in the packet. To commit a crime, a person must intend to do an act which is against the law. While it is not necessary that a person knows the act is against the law, it is necessary that the person was aware he was doing the act and that he did it voluntarily, not by mistake or accident. You may, but are not required to, conclude a person intends the natural results of his acts. Specific intent means not only being aware of doing an act and doing it voluntarily, but in addition, doing it with a specific purpose in mind. Because determining the defendant's specific intent requires you to decide what he was thinking when an act was done, it is seldom capable of direct proof. Therefore, you should consider the facts and circumstances surrounding the act to determine the defendant's specific intent. You may, but are not required to, conclude a person intends the natural results of his acts. Instruction number 21. The state has charged the defendant with murder in the first degree. The state must prove all of the following elements as set forth below. On or about the 19th day of December, 1979, Jerry Burns stabbed Michelle Martinko. Number 2, Michelle Martinko died as a result of being stabbed. Number 3, Jerry Burns acted with malice aforethought. Number 4, Jerry Burns acted willfully, deliberately, premeditatedly, and with a specific intent to kill Michelle Martinko. If the state has proved all of the elements, the defendant is guilty of murder in the first degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the first degree. You will then consider the charge of murder in the second degree as explained in instruction number 29. Instruction number 22. Concerning element number 2 of instruction number 21, wounds inflicted by the defendant resulted in the death of Michelle Martinko if they caused or directly contributed to her death. Concerning element number 4 of instruction number 21, willful means intentional or by fixed design or purpose and not accidental. To deliberate is to weigh in one's mind, to consider, to contemplate, or to reflect. Premeditate is to think or ponder upon a matter before acting. Deliberation and premeditation need not exist for any particular length of time, but must exist before and at the time of the act resulting in death. Instruction number 24. Concerning element number 3 of instruction number 21, malice is a state of mind which leads one to intentionally do a wrongful act to the injury of another out of actual hatred or with an evil or unlawful purpose. It may be established by evidence of actual hatred or by proof of a deliberate or fixed intent to do injury. It may be found from the acts and conduct of the defendant and the means used in doing the wrongful and injurious act. Malice requires only such deliberation that would make a person appreciate and understand the nature of the act and its consequences, as distinguished from an act done in the heat of passion. Malice aforethought is a fixed purpose or design to do some physical harm to another, which exists before and at the time the act is committed. It does not have to exist for any particular length of time. Instruction number 25. If a person has the opportunity to deliberate and uses a dangerous weapon against another, resulting in death, you may, but are not required to, infer that the weapon was used with malice, premeditation, and a specific intent to kill. Instruction number 26. Malice aforethought may be inferred from the defendant's use of a dangerous weapon. Instruction number 27. A dangerous weapon is any device or instrument designed primarily for the use in inflicting death or injury, and when used in its designed manner is capable of inflicting death. It is also any sort of instrument or device which is actually used in such a way as to indicate the user intended to inflict death or serious injury, and when so used is capable of inflicting death. Instruction number 28. Deliberation and premeditation need not exist for any particular length of time, but must exist before and at the time of the act resulting in death. Instruction number 29. The state must prove all of the following elements of murder in the second degree. Number 1, on or about the 19th day of December, 1979, Jerry Burns stabbed Michelle Martinko. Number 2, Michelle Martinko died as a result of being stabbed. Number 3, Jerry Burns acted with malice aforethought. If the state has proved all of the elements, the defendant is guilty of murder in the second degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the second degree, and you will then consider the charge of voluntary manslaughter. Murder in the second degree does not require a specific intent to kill another person. The state must prove all of the following elements of voluntary manslaughter. on or about the 19th day of December, 1979, Jerry Burns intentionally stabbed Michelle Martinko. Number 2, Michelle Martinko died as a result of being stabbed. Number 3, the stabbing was done solely as the result of a sudden, violent, and irresistible passion resulting from serious provocation. If the state has proved all of the elements, the defendant is guilty of voluntary manslaughter. If the state has failed to prove any of the elements, the defendant is not guilty of voluntary manslaughter, and you will then consider the charge of involuntary manslaughter, public offense, as explained later. Concerning element number 3 in the marshalling instruction for voluntary manslaughter, a serious provocation is conduct that would cause a reasonable person to have a sudden, violent, and irresistible passion. Passion is not sudden, violent, and irresistible if there is an interval of time during which a reasonable person would, under the circumstances, have time to reflect and bring his or her passion under control and suppress the impulse to kill. Words alone, however abusive or insulting, cannot be serious provocation. Regarding the offense of involuntary manslaughter, public offense, the state must prove both of the following elements. On or about the 19th day of December 1979, the defendant recklessly committed the crime of assault. Number 2, when the defendant committed the crime, the defendant unintentionally caused the death of Michelle Martinko. If the state has proved both the elements, the defendant is guilty of involuntary manslaughter, public offense. If the state has failed to prove either of the elements, the defendant is not guilty of involuntary manslaughter, public offense, and you will then consider the charge of involuntary manslaughter, reckless conduct. Concerning element number 1 in the marshalling instruction for involuntary manslaughter, public offense, an assault is committed when a person does an act which is meant to cause pain or injury, result in physical contact which will be insulting or offensive, place another in fear of immediate physical contact which will be painful, injurious, insulting, or offensive to another person when coupled with the apparent ability to do the act, or a person intentionally points a firearm toward another or intentionally displays a dangerous weapon in a threatening manner toward another. Regarding the offense of involuntary manslaughter, reckless conduct, the state must prove all of the following. Number 1, on or about the 19th day of December 1979, the defendant recklessly stabbed Michelle Martinko. Number 2, the defendant did the act in a manner likely to cause death or serious injury. Number 3, by doing the act, the defendant unintentionally caused the death of Michelle Martinko. If the state has proved all of the elements, the defendant is guilty of involuntary manslaughter, reckless conduct. If the state has failed to prove any one of the elements, the defendant is not guilty. A person is reckless or acts recklessly when he willfully disregards the safety of persons or property. It is more than a lack of reasonable care which may cause unintentional injury. Recklessness is conduct which is consciously done with willful disregard of the consequences. For recklessness to exist, the act must be highly dangerous. In addition, the danger must be so obvious that the actor knows or should reasonably foresee that harm will more likely than not result from the act. Though recklessness is willful, it is not intentional in the sense that a harm is intended to result. At this time, ladies and gentlemen, it is the place in the trial, the time in the trial for each of the parties to present what's called a closing argument. Closing arguments, along with the opening statements, are not evidence, but this is an opportunity over the last 7-8 days, you received a tremendous amount of information and evidence. And the closing arguments are an opportunity for each side to put that evidence into an order and to argue to you what each party believes that the evidence that's presented means and its significance. As you noticed throughout the trial, there was a pattern. The state goes first, and the state will continue to go first. They will give an initial closing argument, followed by a summation by Mr. Spies on behalf of Mr. Burns. And then because the state has the burden of proof, the state will have an opportunity to again address you in what's called a rebuttal closing argument. I would ask you to give the attorneys, as you have all week, your attention, and I want you to know that as I indicated, the attorneys are trying to give you a framework again and present to you their best belief of what the evidence shows. They are not at any time trying to mislead you. Obviously, as the judges of the facts, it will be up to you to determine what facts you deem credible and the facts on which you will base your determination and your verdict in this case. But the summations that you will hear over the next couple of hours are the understanding of the evidence by each of the sides, and you should continue to give them your close attention.